Good morning, everyone. Thank you so much for joining us. I think we can go ahead and get started. I am Clemence Kuchera, and I'm the Assistant Dean for the Graduate Law Programs. And with me is my colleague, Professor Harder, who teaches Water Resources Law at McGeorge, in addition to many other courses. She's also our Faculty Director for the online programs and has been key in developing the MSL program that we will be discussing today, in addition to talking about this important topic. My colleague Brendan Webb is also here, who is an admission counselor, and he'll be able to answer any of your questions regarding the application process or regarding the MSL program at the end of this presentation. So I think with this, I'm going to turn it over to you, Professor Harder.
Thank you, Dean Kuchera, and welcome to everybody who's here today. Just a brief word about our master's program, and we'll come back to some information about the master's program at the end of my presentation. So we have a Master of Science in Law, also known as an MSL, with a couple of concentrations, one in Government Law and Policy, and today we're talking about our program in Water and Environmental Law. The two are closely connected and complement each other. The MSL program is for recent graduates and professionals who are out in the workforce who want a practical knowledge of law and policy, but who do not want to represent clients, who do not want to be lawyers, but want that working expertise. So a lot of the different professions that benefit from this kind of degree we've seen over the years are consultants, agency employees and managers, legislative staff, and municipal staff, and anybody really who encounters legislative and regulatory matters in their work. So McGeorge, I'm pleased to say, has a deep expertise in water and government, and we'd be happy to share the depth of our programs in those areas with you. The MSL degree could be earned on a part-time or full-time basis. In our online program, the program is a part-time program. It is fully online, interactive, and asynchronous, and I'll explain more about that, what that means in a bit. But before we get to that, I wanted to turn to our substance today, which I'm very excited to be talking about, which is the idea of updating California water law to address drought and climate change, an important topic in California. And the lessons that we draw in this area are actually applicable all across the United States and in other countries as well. So to start us off, I wanted to talk a little bit about the nature of drought in California. Now you see here on your screen, one of my favorite characters in US history. This is John Wesley Powell. John Wesley Powell was an important statesman in US history. He accomplished many different things, including rafting down the Colorado River the first time in a wooden boat with one arm, which he had lost the other arm in the Civil War. He's amazing. Well, one of the things that John Wesley Powell did is he did a survey of all of the Western states for the federal government and identified what water resources they had available to them. His findings are published in an 1878 report called The Arid Lands. And in that report, he noted that in the Western states, including California, there's what's called a special kind of scarcity. It's not that there isn't enough water overall. It's that we have water in the wrong places at the wrong time. So we talk about scarcity in the West and in California in terms of seasonal, meaning winter versus summer, annual, meaning from year to year, and geographic scarcity. We have a lot of water in some areas and less in others. So in California, you have, when you're lucky, wet winters and springs and dry summers and falls. Our water years, we have going anywhere from critically dry years, which we've had a number of recently, all the way to very wet years with what we call normal or sometimes called average years in between. Geographically, we have a much more water in the northern part of the state and sometimes on the coast, depending on where you are, and much less water in the center of the state and in Southern California. We do tend to get a lot of water when water falls in the eastern portion of the state in the Sierra Nevada mountains in those high watersheds. So as a result of these special kinds of scarcity, it's said that California experiences perpetual drought. We also say that California is a climate of extremes because when it's not in a drought phase, it's flooding. This is a natural condition in an arid climate, and it's natural in California. And of course, recently we've heard, just reported in the New York Times last week, they reported that many of the states in the United States, including California, are in what they call a mega drought, which we've seen the driest conditions for a 20 or 30-year period that we've seen in several centuries, and that 30 to 50% of that change is attributable to climate change. The usual number in the press you see reported is 40%. So if you look at the map on your screen, you'll see this is a map from February 15th, and it's a map of the state of California. The red areas are extreme drought, and you see that creeping up in the northern part of the state. In the middle and almost the entire rest of the state, you see severe drought, that dark orange, and we are moving towards severe drought, extreme drought in many areas. So we have a number of challenges to tackle in water law. And the question is, are our water law tools poised to help us tackle those challenges? And the answer is yes and no. There are some elements to our water law that are very capable, very flexible of addressing drought, even in the face of climate change. There are others that need to be changed. So some of the core basics for California water law: we have a constitutional standard for water law. In legal parlance, constitutions are the controlling law. They govern over everything else, whether it's a law enacted by the state legislature or a law enacted by an agency. In California, the constitutional standard is that water must be put to reasonable, beneficial use to the fullest extent possible. And that standard reflects those arid conditions I was just talking about. In California, we have dual property rights in water. The Water Code, which consists of statutes enacted by the state legislature, laws enacted by the state legislature, says that water belongs to the people of the state, but the state may allocate the private right to water to individuals. So that creates a dual interest in water in California, which has both private rights in water and public rights in water, and we have to accommodate both. So when we talk about those private rights in water, there are two general categories. One is surface water rights, and we have three different kinds, very broadly speaking, of surface water rights. Riparian rights, which come into being when somebody owns property. It's a function of property ownership. No permit is needed. And then appropriative rights, which are water that's acquired when it's put to beneficial use, putting the water to some use that has social value, like in cities, or to produce food and fiber through crops or hydropower. So of those appropriative rights, we have two kinds. One is called pre-14, the other post-14. Why is that 1914 date important? It's because in 1913, in a law that took effect in 1914, the state created the California State Water Resources Control Board. And the state gave the water board, through the water codes, permitting authority over only one kind of surface water right. And those are rights that post-dated that water code. The rest are under the jurisdiction. There's no permit needed. They're under the regulatory jurisdiction of the courts. There is some regulatory jurisdiction on the part of the state board over riparian and pre-14s, but it's somewhat limited, although the law around that is still developing. And that's a major area for focus when we talk about change. Groundwater is even more complicated. I will just say here that there are likewise land-based rights to groundwater, overlying rights, and use-based rights to groundwater, appropriative rights. There's no 1914 distinction in groundwater rights, and the State Water Board does not have permitting authority. But it does have some regulatory authority newly allocated to it in 2014 under the Sustainable Groundwater Management Act, which is a whole other topic, but one I love to talk about. So I wanted to talk about some current proposals to reform California water law to meet the challenges of drought and climate change. And one reform proposal in particular I want to talk about was inspired by a prior reform proposal, and that is the Governor's Commission to Review Water Rights Law, which was created by then Governor Jerry Brown in 1977. Now, this distinguished group put out a report in 1978, which examined deficiencies in California water law and made a number of recommendations. You can access that 1978 report online for free at this URL. And for those of you attending the webinar today, you'll receive a copy of this PowerPoint after the webinar, the recording, I should say, so you'll be able to go to that URL. You should also feel free to contact me if you'd like, and I'll give you my contact information at the end. So Governor Jerry Brown, of course, has a strong history in California water. His father was also former governor of California. You see them both pictured here in the 70s, Pat Brown. And Governor Pat Brown actually approved the construction of our state water project, which runs up and down the length of California. So there's a strong legacy on the part of both, for better or worse, depending on where you stand, with respect to water in California. So building on the governor's report of 1978, the Governor's Commission report, a new effort to reform California water law was initiated. I think it was as far back as 2020, 2021, but the report came out just recently in 2022. And I am so proud to be part of this distinguished group of people. The group includes notably Cliff Lee, who was a staff attorney on the 1978 Governor's Commission report, and a former California Deputy Attorney General, myself, Tam Dodek, who's a former member of the State Water Resources Control Board, Professor Holly Doremus from Berkeley, Professor Rick Frank from Davis, Professor Camille Panu from Irvine, and Professor Buzz Thompson from Stanford. A great, wonderful group of people I had the pleasure of working with. We were facilitated by an environmental nonprofit called the Planning and Conservation League, which didn't have any influence over our recommendations. They just created the Zoom links and acted as a facilitator when we had our conversations. So our final report was issued on February 3rd, 2022. You can access it at the Planning and Conservation League website at pcl.org. And it's called Updating California Water Law to Address Drought and Climate Change. So I'm going to talk briefly about our recommendations. Those recommendations come in three categories. The first is implementing the human right to water. A second is adjusting the tools available to the State Water Resources Control Board with respect to post-1914 rights and pre-1914 and riparian rights. And the third is to address the extinction crisis in California's native fisheries. So with respect to the human right to water, the report ultimately had three recommendations. The first was to try to give some teeth to a law that was enacted in 2012. It became effective in 2013, which is California's human right to water law. And our idea there was to require agencies that are charged with managing groundwater under that Sustainable Groundwater Management Act I mentioned before, to mitigate, meaning to compensate for, to reduce or eliminate the adverse impacts of pumping groundwater on wells that depend on that groundwater for drinking water purposes. Now, in most places across California, those wells are depended upon by disadvantaged and underserved communities, many of whom are dominated by minority populations. And so implementing this protection against the impact of pumping on domestic wells and protecting drinking water quality really is a human right to water issue. So that was one of our top recommendations. We recommended that the State Water Resources Control Board explore funding to allow environmental nonprofits and California Native American tribes to participate in state board proceedings, and so to help provide funding for their participation, because often they're not able to participate as a result of a lack of funds. And this would be modeled after a program created by the California Public Utility Commission. And finally, we recommended that one member of the State Water Board and the regional water quality control boards, over which the State Water Board has authority, to be qualified in the field of environmental justice, specifically water justice. And that's a phrase we use to refer to ensuring safe, reliable water supply for disadvantaged communities. So these are our 3 requirements. I should say before I leave this that currently one member of the State Water Resources Control Board, Laurel Firestone, is in fact a experienced in environmental and water justice. So that's wonderful. We want to make that a requirement for the future. And I'm pleased to say that Laurel Firestone has a strong relationship with McGeorge, and in the past has appeared at many events talking about water justice. I'm very proud of that. So our second set of recommendations had to do with updating the State Water Resources Control Board's tools to address drought and climate change. And I'll just go through these briefly. One was to provide greater authority to engage in what we call adjudication. Adjudication means the state board would have the ability to bring water users into the board and to decide who has which water rights on a given system, and then decide how much each person can take, and if they need to reduce their historical diversions under their water rights. The State Water Board has some authority under adjudication now, but we believe that authority needed to be strengthened. Likewise, we suggested the State Water Board have new authorities to verify water rights. That is, to confirm the validity of a particular water right and to ensure that the water user is diverting water consistent with the terms and conditions of those rights. You might be shocked to know in a state with water as scarce as California that we don't actually have really strong tools to do that. But we don't. The State Water Board has some great tools to verify water rights, but there are some ambiguities, some things that really need clarifying and strengthening. So we have recommended reforms around that. We've also suggested giving the State Water Board what's called interim relief authority on a permanent basis. That sounds like an oxymoron, but interim relief means in between while we're waiting. And what that relief would do, it would give the state board the ability to act quickly during drought periods, which they can only do currently using their emergency authorities, which have certain parameters on them. So we want to give them drought response authority on a permanent basis. We're also recommending that the State Water Board follow up on some of its current fantastic initiatives to improve data and monitoring of water use in California by proposing some pilot projects for real-time monitoring, meaning we'd be able to measure how much water is being used in a given watershed as it's happening. Again, you might be surprised to know we don't do that in California already. The technology has not been there. It is, we believe, there now. It's expensive and it's not easy, but it's something we really need to do in the face of the challenges of climate change. And finally, we're suggesting that the State Water Board take the opportunity to adopt regulations to address the amount of water available for diversions, taking into account the changes wrought by climate change. What do I mean by that? When the State Water Board issues water rights, it has to figure out how much water is available in a given system. And to do that, it has engineers and it runs these calculations. Well, historically, to figure out how much water is available, the engineers will look at a prior period of time. It's called a base period. It's usually 10 years or 20 years or 30 years, and it encompasses both wet and dry years. Remember, we talked about the fact that sometimes it rains a lot, that's a wet year. Sometimes it doesn't, that's a dry year, and there's gradations in between. So typically, to figure out that availability, the State Water Board looks at this backward-looking period. The problem this team of professors identified was that by looking at this backward-looking period, you're not accounting for changes in precipitation, changes in snowmelt, and changes in temperatures that are being wrought by climate change. And so the State Water Board needs some new engineering, some new approaches to making those calculations work. And we are suggesting the State Water Board expressly address that issue as a priority. And finally, our third set of recommendations addressed the extinction crisis facing California's native fisheries. So there are a number of fish populations in California that are under some stress from the multiple demands on water in California. And water is important for many diverse needs in California, for cities, for hydropower, for farms, for food and fiber, for recreation, and for in-stream flow to support wetlands, to support habitat, aquatic and riparian habitat, and to support wildlife and fish populations. Those are just some of the uses to which we put water in California. That's a lot of demand on our supplies. The problem, one of the key problems, one of the key challenges in California water is that when the system was invented, we didn't set aside supplies for the environment. And then the water was allocated to all of these other important uses, drinking water, agriculture, whatever the case may be. And now that we are realizing that the environment needs more water, the only solution that we have is to take water away from existing uses. And in some cases, we have some innovative approaches to creating new water, like recycle water capture, stormwater capture, groundwater storage. We're looking at all of these options. But this problem of allocating water to the environment remains a challenge. And so we're looking for opportunities, innovative opportunities to solve that problem. One of the innovations the State Water Board itself came up with was to adopt what's called a water quality control plan. Now, the water quality control plan for the most important watershed in California, the Sacramento-San Joaquin Bay Delta. You see a picture of the Delta right here behind me. That water quality control plan has been in progress for several decades. But in recent years, the State Water Board has proposed an innovation, and that is to adopt as water quality standards in-stream flow standards, a requirement to keep a certain amount of percentage of flow in stream. Now, for various reasons, very understandable, both technical and legal and political, that process has taken a long time. And while that process is taking a long time, the fish populations are crashing. There was some recent news about the salmon populations in California that was very poor. And in some seasons, for some runs of salmon, we're looking at less than 5% returns on a particular juvenile year, the young salmon returning. So this is a situation in which quick action is needed. And so this professor group suggested that the legislature adopt a deadline to help the State Water Board, help the stakeholders who are all involved in this process to come to agreement faster so that we can get that water quality control plan adopted by December 2023 and implement those protections for fish. And finally, we suggested amending a provision of our current Fish and Game Code in California. Section 5937 says that every owner of a dam has to allow sufficient water below the dam to keep the fish in good condition. And there was a suggestion from some environmental groups that although that law probably includes water for water quality, it would be better if it was clearer that it included water quality. And so our professor group agreed and suggested clarifying section 5937 to say sufficient water or water of sufficient quantity and quality to keep fish in good condition. Now that's important because one of the major issues facing the salmon I talked about is water temperature, which is a water quality parameter. And so if 5937 addressed water quality, it would help the state address those temperature issues. So those are our primary recommendations for addressing California water law. What are the next steps? Well, I'm pleased to say that I'm not directly involved in this particular process, but I sometimes get updates that some of the recommendations are being incorporated into pending legislation right now. Some are being considered for regulatory implementation. And our group has remained available to talk to the decision makers about what we're proposing and to help them noodle through good ideas. We also are advocating support for other groups who are working on additional recommendations. I think we all agreed unanimously that these reforms that we suggested were reforms we thought were practical and feasible, but that were certainly not the universe of possible reforms. And we want to support other reforms from other groups. And I know of several that are working on some. So that is an update on changing California's water law to address drought and climate change. I am going to talk just for a minute about our water and environmental law curriculum in our MSL program at McGeorge, and then you'll have the opportunity to ask questions. And I can't wait to engage with you around those questions. So Dean Kuchera, should I go through this curriculum now? Is that a good idea?
Yes, absolutely.
Great.
So as you're going through it, if our audience wants to start thinking about their questions, we will take questions via the chat or the Q&A function.
Thank you. So our Master of Science in Law degree is a 26-unit degree. And of that, so that's for both concentrations, government law and policy, and water and environmental law. This you see here is the water and environmental law curriculum. It's a part-time program that's spread over 2 years, although some flexibility in how that's arranged. Dean Kuchera's office is very good at working with people. But the standard program would be for someone to enter their first year and in their first semester to take courses in Introduction to Legal Analysis, where we teach you the language and the basic principles of analysis. And you get to actually apply those skills in a contracts course that focuses on teaching you analytical skills so you understand what lawyers do and how they think about the law. In the second semester, you would take a class in legislatures and lawmaking, which focuses on the statutory drafting process and how to read statutes that have already been enacted the way that a court or a lawyer would. And that would give you the skills you need to recommend changes, to help an employer understand a statute, to draft a statute, or to comment on a draft statute. At the same time, in the second semester, you'd have the ability you would be taking this class called the Executive Branch in the Administrative State, which I have to say is one of my all-time favorite classes. It's an administrative law class, and water and environmental law areas are really deeply centrally an agency practice. You are either working with agencies or for agencies, presenting to agencies, or trying to get permits from agencies. So it's an agency practice, and this class will give you all of the skills you need to understand how agencies are structured, how they write regulations, how to interpret those regulations, how courts and lawyers do that. So you can provide all of that advice. You can go out and write comment letters, or you can respond to comment letters with the knowledge of how the process works. We have 2 skills courses. These are summer courses. One is a skills course in leadership in organizations that focuses on those agencies, either working with agencies or working within an agency, and persuasive public speaking, which focuses on the skills that you need to present to teams within your organization, whether it's a private company or within agencies, to speak to the media or to give presentations, whatever the case may be. We then have 2 required courses in the second year, which go to that water and environmental expertise that you'd be developing. One is water resources law, which is a course that I teach. It's my favorite thing in the whole world. And then we have a course in environmental law, which is a survey course of many different important environmental laws, including the Endangered Species Act or the National Environmental Policy Act. You also have electives that you have the opportunity to choose 2 courses from. One that I'm very proud of, you see here, is a course in water and environmental justice, which focuses on those disadvantaged communities. And I'll talk more about that in a second. And you see the rest of the opportunities here. One I want to call out to you is this opportunity to undertake a master's thesis or a faculty-directed research, which is to choose a topic that you could dig really deep into, and if you choose, produce a paper of publishable quality or other product. And I've done many of those with our graduate students. They're wonderful. So when we look at the courses, at these courses in some additional depth, We talk about water resources law, which I mentioned I teach. We look not only at water rights, but also at federal and tribal rights, the human right to water, the public trust doctrine, and other mechanisms for in-stream flow. As I mentioned, that's one of the key opportunities and challenges in water law today. That survey course in environmental law, you can see here, in addition to the Endangered Species Act, we look at the National Environmental Policy Act, the Clean Water Act, the Clean Air Act, hazardous waste laws, and climate change. And then, of course, there's that wonderful new course in water and environmental justice, which explores the deep history of water allocation through a critical race lens, investigating legal and institutional frameworks for water supply and the very deeply related issue of land use, with a special focus on drinking water. So that's an excellent class that will give you a really deep understanding of the local agencies that govern water today and how they interact with these disadvantaged communities, financing mechanisms, water quality, and other issues. So all of our online courses at McGeorge include what we call asynchronous lectures, where you don't have to be in the same place at the same time. They are chunked in small bits, so you don't sit there watching a long lecture. Our students tend to love the way that they're chunked out. You do interact substantially with your professors and your classmates on a weekly basis through our discussion boards. There are many learning tools, including ungraded quizzes and special ungraded discussion boards. The assignments are prioritized to be practical, to take place in the real world. You get regular feedback from your professor. That's a priority for our program. And I'm pleased to say we do get really good feedback on our feedback. And we have a really wonderful community that we've created. There are many students that I've only met online with whom I have years and years long relationships. So I think it's a really robust, interactive program. So with that, I will turn the next steps over to Dean Kuchera.
Thank you very much, Professor Harder, for this wonderful presentation of the work that you've done, but also on the programs. So for those of you who are interested in applying for our Masters of Science in Law program, we do everything through GradCast. Again, as Professor Harder mentioned, we will send you this recording so you'll be able to access the link for the online application. Otherwise, you can find it quite easily on our website. We do not have any standardized tests that we require for admission because as this program does not lead to eligibility on taking a bar exam, we thought it was not needed. And indeed, like all of the MSL type degrees that exist in the United States, like none require a GRE or an LSAT test score. You can see that we have a priority application deadline of June 6th. Was a final application deadline of August 1st. Our classes starts quite early in the fall, so August 15th. And then we also have a cohort that starts in January, for those of you who are thinking more about starting in January. And it usually is the second week of January that we start classes. So I think with that in mind, like I encourage you to reach out to us if you're interested in applying for the program. We enjoy Brennan and I, we enjoy meeting with all of you, each of you individually, to talk about your career goals and to see how the MSL program can help you achieve your career goals. If you also have questions for Professor Harder, obviously, please do connect with her. So we will take questions, and I see that we already received a question. So I'm a member of the California State Bar. Does McGeorge has an equivalent LLM degree? Professor Harder?
Sure, yes, I'm very pleased to say that we do. We have an LLM for those who have JDs, a Master of Laws, LLM, in water and environmental law. And so the curriculum is in some senses similar to the one I just outlined, although we do take into account what you've already studied, and you wouldn't be taking those introductory classes, the introduction to legal analysis or the contracts analytical skills, unless for some reason that seems to be a good idea for you. Most of the time they don't. But we can get you into the other classes after you consult with Dean Kuchera's office about what you've taken so far and what your objectives are.
And I see that Brendan has put in the link for the LLM web pages. So thank you so much. if I'm looking up, it's because my chat is put up on my screen. So any other questions? So while we're waiting for questions, let me ask you, Professor Harder, perhaps you could talk a little bit more about practically, how does an MSL degree really help someone who works in this arena or this field of work without being a lawyer? What is really what is the advantage of having an MSL degree?
I think that's a great question. And I'll base my answer off of the feedback that I've gotten from the graduates from our programs. Many of them have used the degree to advance in their current businesses. So if they're an agency or they're a private organization, they have the MSL degree, they are eligible for promotion. They can highlight the skills that they've developed in the MSL program, understanding the language of the law, legal institutions, the basic frameworks for legal analysis, enables them to contribute to their organizations at a higher level of expertise. They can do things like help draft regulations or help the organization understand when something it's drafted might create a problem in the real world. They can engage with other agencies around their regulations. They can do the same things with respect to laws. I know some graduates work in advocacy, so they're trying to promote different changes in the law, and having this expertise helps. Others work in compliance and help their organizations understand how to comply with the law in a way that results in the most good for the public, right? Some balance of protecting the public finance plus protecting the environment, right? And delivering those services of water and electricity and wastewater treatment and flood control and whatever the case may be in a safe and reliable way. So I've seen many of them do all of those things. Others are not in this field yet and want to transition into this field. And so this degree can provide a leg up that way. Another way the degree can help is to help people take a really deep dive into a particular subject, like finance, for example, or public agency requirements like open meetings and Public Records Act, or whatever they really, water marketing, something they want to specialize in. And they can work with me or another appropriate professor to develop that expertise, to perhaps publish a paper on it, and then they can use that expertise for advocacy or to advance or whatever the case may be. So many different options. I love seeing how people use this degree in the real world.
Thank you. Thank you. So another question that we have is, how many students go through the LLM program in a given cohort? So let me answer this one. So as Professor Harder mentioned, like the courses are the same as the MSL degree, with the exception of the foundational skill courses that you do not have to take again. The majority of our LLM students actually do a program in person. For this online program in water and environmental law, it's a very small cohort of students who do that. We probably have like 2 or 3 students every year. But because you take classes with other students, like you end up being in a class of 10 to 15. Our online classes are maxed out at 20 because, as Professor Harder mentioned, we put a strong emphasis in interaction between the students, but also with the professors. So a larger class like tends to be harder for students to get individualized feedback. Professor Harder, anything that you want to add?
I would just add that although the online component to the LLM is small, as Dean Kuchera mentioned, they do interact regularly with these other students who are sometimes JDs and sometimes the MSL students and sometimes public policy students. And that creates this rich interdisciplinary environment that I think is wonderful. And for those LLMs we've had in the program, some of whom are in California and some of whom are not, are out of state, they've really, I know, enjoyed the program and gotten a lot out of it and contributed, I think, meaningfully to that general academic community. So it's small but mighty, I would like to say, about the online LLM component.
Thank you. So another question is, does McGeorge assist students with gaining licensure in California? So for the online programs, it's only online for the LLM. For the LLM program, like, implies that one has already received a prior law degree, and often, if not all the time, the LLM students already have a membership, are already a member of a bar in the United States. For the MSL degree, you cannot take a bar exam. Now, if you were interested in, does McGeorge in general has a program to assist students gaining licensure in California? We do, but those are not part of the online program. So McGeorge has a strong bar prep program to help students as they're studying for either their JD or their LLM program, so to help them prep for the bar exam. Brendan Webb is actually a JD graduate from McGeorge, and he just took the bar exam yesterday and the day before. So he can tell you that in addition to whatever help you're getting from a law school, nearly all, if not all, law students who intend to sit up for a bar exam in California, or pretty much probably anywhere in the United States, like, do enroll in a commercial bar preparation. Brendan, I don't know if you want to.
Sorry, what's the specific question?
Students do, in addition of doing the bar preparation courses at McGeorge, do also sign up for commercial bar preparation.
Right, yeah. There's a class for the JD students. It's called PASS, and it's designed to prepare you to take the bar. It's building up the skills to write an effective bar essay, and there's a lot. Every week you work on mock essays, and just really the repetition helps cement it in your brain. But on top of that, there are also commercial bar prep courses out there. I took one and it helped a lot, but sometimes they could cost a lot of money, I guess. So it really helps that the school has those options available.
Thank you. Thank you. So even as an attorney, if you're already an attorney and you want to do an LLM program first, you can certainly do the LLM program, not the online program. You can do the in-person program, and then you would have access to the PASS 1 and the PASS 2 courses that Brendan mentioned. We also have a BEAT program that helps students throughout the summer to do it. So I think this is available to all of the students enrolled at McGeorge, but for the online students, we don't have an online version of those courses. I hope this answers your question, but I'm happy to meet with the person who asked the question. Like, I'm happy to meet with you one-on-one to talk a little bit more about what we offer. So another question that I see is this MSL program available to people who are not currently in the field and or have received a degree in a different major? Professor Horder?
The answer is yes, absolutely. And I've had many people come to water and environmental law from different fields, and they are relying on this program to help them develop that expertise. So that's something we're very ready to do. And I'm just thinking of one recent student who's so excited to now move into this field after having spent, I think, 12 years in another field, and just was really inspired by water and environmental law. And she is now looking at that transition with a lot of options and very excited. So the answer is yes, absolutely. And I'd be happy to talk more specifics about what any particular person is doing now and what their goals are and how the program can help them on a one-on-one basis. Feel free to reach out to me. You can also reach out directly to Dean Kuchera's office at graduatelaw@pacific.edu.
Thank you.